Welcome back to another Senior Learning Institute's educational moment, where older adults and their loved ones turn for honest and straightforward information. In just a few minutes, you'll enjoy bite-sized, easily digestible nuggets of knowledge, empowering you to make the right decision the first time. So without further ado, here's our founder, certified senior advisor, seniors real estate specialist, nationally syndicated podcaster and speaker, the advocate you can trust, Mr. Ted Gottlieb.
There's something to be said for the written word. This Senior Learning Institute educational moment addresses financial power of attorneys. Shawn Estep is an estate planning attorney, principal of the Estep Law Firm, member of the National Academy of Elder Law Attorneys, and a proud sponsor of the 2020 Senior Learning Institute Seminar Series. Shawn, for those who are new to the world of estate planning terminology, what is a power of attorney and why is it often considered an essential part of an estate plan?
Okay, so a power of attorney is one of the tools that estate planning and elder law attorneys like myself use to help the families we serve if they become incapacitated or if they've decided that for some reason they don't have the capability of managing their finances themselves, that someone they trust can take over. And by financial, I mean day-to-day things like managing checking accounts, financial accounts, accessing employer information, down the road, if you become incapacitated, actually making certain personal, non-healthcare related decisions for you. So that's what a power of attorney for finance is.
Got it. Now, one of the things about power of attorneys, or POAs as they're often termed, is that they're only in effect while a person who appoints the power of attorney is alive. Can you elaborate on that?
Sure. So in essence, this power of attorney is that person who creates the power. We call them the principal. That principal, that's their power while they're alive and well. And with a couple of exceptions, when that power of attorney or when that principal dies, that power of attorney stops being effective. So it's really only good while you're alive and well, or if you become incapacitated. And there are some powers of attorney that if you become incapacitated, they're also no longer effective. So what you're looking for is a durable power of attorney. That means that the power of attorney is effective if you become incapacitated, okay? And again, there's more to that, and we'll talk about that in a few minutes, I'm sure.
Got it. Let's talk about that term capacity for a minute, because oftentimes it's misunderstood. So when you're talking about capacity, we have to have that when we're putting this together, but what is capacity really, or how is it defined?
Okay, so capacity is just defined by one of three methods. Okay, so either one or two physicians make a determination that you're incapacitated. And in that instance, they say that you cannot make financial or potentially healthcare decisions on your own behalf, that you need someone else, that your condition, whether it's physical or mental, is so degraded that you can't make those decisions yourself. A court of competent jurisdiction can make that same determination. Or if you're missing, absent, or detained for more than 30 days, even though you don't have any physical or mental incapacity, if you're gone, someone needs to be able to make those decisions for you. So that's the incapacity issue and how you make that determination.
Thank you. We're speaking with estate planning attorney Shawn Estep. Shawn, today, as you noted, we're talking about the financial power of attorney. Let's define that. Tell us what it does, what it can't do, and when it's effective.
Okay, so let's just take a logical step through this. So a financial power of attorney allows someone you choose who you trust, a person called an agent or attorney in fact, gives them the ability to make day-to-day financial decisions on your behalf. And again, that's going to be things like accessing checking accounts, financial accounts, brokerage accounts, IRAs, 401ks, employer information. They can also make certain personal decisions for you, take you to the ball game, take you on trips, things like that. Those are kind of the powers that they have. Accessing your documents as needed, again, in order to make certain decisions for you. So those are kind of the powers that financial power of attorney can do. And those are things that are owned by you as an individual that they can manage. If you have something that's owned by a trust for which you are the grantor, the person that created it, those things they can't manage unless the trust itself specifically states that a trustee or a attorney-in-fact can manage the property. So you have to be careful that if you don't own something, your power of attorney can't manage it. So that's what it can't do under the financial powers of attorney. Does that make sense?
Yeah, it makes sense. So how do we, so there's a lot of responsibility for wherever this POA is going to be. How do we determine who that POA is? I mean, I have to imagine that you've got, let's assume you have a couple of kids and you decide that one's going to be the POA and one's not. I have to think that's going to create some friction. How do you know which is the best person to go with? How do you know whether you should use a child or not? I mean, how do we figure that part out?
That's really a very good question, and that's one of the most important questions, and oftentimes the most difficult that someone doing their estate planning is going to have, because they know who they want to have get stuff, but who do they trust to manage it? So at the outset, you want to make sure that you're having somebody that's capable financially, that's competent financially. So you don't want a family member who can't balance their own checkbook, or is more interested in traveling and not being responsible. You don't want that person being a attorney-in-fact. You also want to make sure it's somebody, if possible, that's close, so that they can make decisions for you in the locality you're in. So that could be very important. So the first thing is to make sure that you get the right person. If you get somebody that's maybe not as good, but you definitely want them involved in the process, you can have two people act as attorney-in-fact. But then you have to make the decision. Do both of those people have to make a decision at the same time in order to do activities on behalf of the principal, or can they each do it alone? Again, that's a difficult question, and it's part of the counseling process, having a conversation instead of just willy-nilly picking people. You have a conversation about who maybe makes the most sense. And then if, at the end of the day, the wrong person was chosen simply because their life changed, because oftentimes these financial powers of attorney have been in place for 5, 10, 15 years. Imagine the things that happen in your life over the last 5, 10, 15 years. It's amazing. My kid went from being irresponsible and so forth to being a responsible adult in 15 years. So things change. So you have to make sure that you choose the right people. But if, again, you don't, then there are laws in the state on books that say that if you don't act properly, according to your fiduciary duties, that's the technical term, then you can be removed as attorney-in-fact. But that requires a court to remove you as a attorney-in-fact. So the damage may be done by the time you do that.
Okay, but if I still have capacity and I choose that child number one, who was my power of attorney, is no longer able to do that efficiently, or I no longer want that, I want to switch it up, I can still do that, right?
You can always remove them. And sometimes what we do, just as kind of a side note, is that sometimes we will make a child or a person we trust attorney-in-fact immediately. So for instance, right now is a great time to think about doing this. If you can't get out of your independent living community or assisted living community or nursing home community, and you need somebody to make deposits in a checking account or go sign documents because you can't get out of that community, you want someone to be your attorney-in-fact immediately. So instead of having what we call a spring durable power of attorney that only occurs when one of those 3 determinations of capacity occurs, we make somebody an immediate attorney-in-fact. We can do that right away. The thing you want to do, though, is you want to make sure that that immediate durable power of attorney has a limit on it, and that limit is once this whole virus thing is over, we stop. Why? Because you don't necessarily want that person carrying on and continuing to work on your behalf. You want to have a specific date at which that ends.
Okay, makes sense. So let's say I have an old power of attorney, or I don't have one, but I know I need one. What does it take to draw one up?
Really, pretty much, it's just going to be a conversation. So my goal is to find out how that person needs to be taken care of. Do they need somebody to immediately take over? Do they need somebody that needs to act with another person? Do they need this to be springing durable power? In other words, they don't need it to occur immediately. Maybe they can wait, or do they need it to occur immediately? Do they need specific powers to allow that attorney, in fact, to manage their health care costs later down the road in terms of maybe gifting, so that if they're in a crisis and need to go into a nursing home, can we use that power of attorney to manage their assets so that their assets aren't used up again during a Medicaid crisis? So those are all things we'll talk about. A general run-of-the-mill durable power of attorney off the internet might be okay for certain day-to-day things, but you're not going to get that conversation that determines whether you need something that's a little more robust, that manages more assets or manages assets differently, or takes in consideration, again, crisis planning or other things.
Right. Well, in my head, one of the most important things is that we do this while we still have capacity, because I've seen situations where someone has been diagnosed with a cognitive impairment, and next thing you know, they can't make these decisions anymore because of those issues.
Right. I've had clients come into the office and have decided that they're just not ready. That it's too expensive, whatever the reason is, and it's oftentimes a good reason. Okay, and then they come back with their children, 6 months, a year, 2 years later, whatever it is, and now we're in a situation where they really need those powers of attorney. Unfortunately, at that point in time, they've gone past the point where they can actually sign documents because they're no longer capable. They don't have capacity. So now we have to use the backup plan, and the backup plan is what's called probate, a guardianship. A guardianship is really a living probate for families that did not plan forward. I'm not saying that you wouldn't end up potentially with a limited guardianship down the road, even if you have powers of attorney. It's just that it would be a limited guardianship versus a broad guardianship, because if you have the powers of attorney, those powers still work even though you have a guardianship. You would simply have one person as your attorney in fact that can do all the things you've asked them to with those powers that they don't have to report back to the court on, and then a limited set of things, again, that same person would do under the guardianship. Does that make sense?
It does. Now, and probate has its own issues, and we can talk about that some other time. But the one thing that you mentioned that kind of gave me a segue into cost, and I know probate starts to get very expensive, but we like to let folks know, give them rough ideas in regard to what it costs to actually put one of these powers of attorney together. So we're not holding you to a firm number, but is there a range that someone can expect to budget to put a financial power of attorney together?
Typically, when someone's wanting a financial power of attorney or healthcare power of attorney or will or whatever, they're not looking particularly for that individual document. If they are, it's oftentimes for a limited purpose. So if it's for a limited purpose, we usually start at a relatively low cost. Maybe for one document for a limited purpose, it's somewhere between $150 and $250. Again, just depending on what they're trying to accomplish. More likely what they're going to do is they're going to do something where they're going to want some either a will-based package or trust-based package. And again, those are more comprehensive, and obviously the cost is going to be greater for those packages. But just for a separate power, anywhere from $150 to $250, again, depending on how complex that power is.
Gotcha. And one of the approaches that I take is I always try to put a plan together. I put the financial advisor together with the elder law attorney and the estate planning attorney, and we put a plan together so that we do have that comprehensive plan. But as you mentioned, sometimes we do have to just come in and take care of things. And I'd say for $150 or whatever that number ends up being, it's quite reasonable. Last question for you is in regard to who actually should maintain and have copies of the powers of attorney? How does that work?
That's really up to the client to decide. So the way I counsel a client is if you have a springing durable power of attorney, make sure your family knows where it is, but you don't necessarily have to give them a copy. Part of the reason that working with an attorney works best, especially an attorney like myself, is that we keep copies of everything in our system. It's an electronic copy. That's okay because electronic copies actually can be valid under certain circumstances. So our goal is to allow the client to make that determination. And if for some reason they don't give that to the child and the child can't find the power of attorney, again, we have copies of all of their documents in-house so we can make sure that they're available. And again, that's something else to think about in terms of cost. You can spend much less on powers of attorney on individual documents, but are those documents available? Sometimes they are, sometimes they're not. And what they're not available, then who's responsible for having a signed copy of it? In our office, again, we have copies of all of their documents. So that's kind of a backup plan and probably worth kind of paying a little bit extra.
Got it. Well, that makes a whole lot of sense. Well, Shawn, thank you so much for the information and your insight. If someone wants to dig a little deeper and get in touch with you, what's the best way for them to do that?
Well, the first way is to call me. Again, my name is Shawn Estep. I'm with the Estep Law Firm, and you can reach me at 636-233-2017. You can also go to our website. You can reach us at www.estep.lawfirm.com.
Great. Now, if somebody calls you, and most estate planning attorneys that I know, they're not going to charge for a consultation call and have that initial conversation. Does that hold firm with you as well?
Yeah, absolutely. I actually met with a client on Tuesday, and she was shocked that I didn't charge her for initial consultation. So yeah, don't be shocked when you come in and we have a little conversation. The only caveat to that is if at the end of the day we do some sort of planning as a part of that initial consultation, typically this will come up in an elder law context. If we do some planning, if we have a plan set at the end of that conversation, you'll know if there's going to be a charge, and you'll be ready for that conversation and ready for that charge because you'll be engaging me as your attorney. Other than that, no, there's no fee for the actual consultation itself.
That's great. Well, we appreciate you doing that for sure. I want to thank the audience for joining us and listening to this Senior Learning Institute educational moment. At the Senior Learning Institute, we strive to provide straightforward and unbiased and free information that will help you make smart decisions the first time. Our whole goal and our mandate is to connect older adults and their advocates with the resources they need, again, without cost or obligation. Things like staying put, estate and financial planning, care management, estate sales, clean out services, home maintenance, and my favorite thing to do is selling the home for as much as possible with absolutely, all the resources that we can put together to maximize how much you actually net from selling that house in any condition anywhere in the U.S. To learn more, please visit us at theseniorlearninginstitute.com. And until next time, I'm Ted Gottlieb, Certified Senior Advisor, Seniors Real Estate Specialist, and founder of the Senior Learning Institute.